Okay, so we have this concept called vicarious liability. Usually when we talk about liability, what happens is that whoever has done the wrong, that person is made answerable, whether we talk about civil or criminal, whether we talk about civil wrongs or crimes. It usually happens that if I have done something, I'm answerable for that. I'm not answerable for what someone else has done. So every person is liable for his wrongful act. If he has done something wrong, he will be liable for that. However, there are certain conditions when law holds a person liable for the act of another. Ideally, whatever I have done, only for that I am made liable. But there are certain situations, or rather, if certain conditions are being satisfied, law can make one person liable for someone else's act also. Now, when we say making one person liable for somebody else's act, it does not mean that we can randomly make a person liable. So there are certain conditions that need to be satisfied, and this is nothing but the concept of vicarious liability, making somebody else liable for someone else's wrong or torts. The liability under this principle is joint and several. When we talk about liability, that someone can be made liable for the wrong of another person. Now, what kind of liability is it? It is called as joint and several liability. So what is joint and several? What is the meaning of joint and several in general?
Responsibility can be vested to one individual or group of individuals.
Yes. So we can, like, it depends on the victim. Okay, victim can decide whether he jointly wants to make the persons liable or he wants to make them liable severally or separately. As in, he cannot file multiple cases. If there are 3 people, he cannot file 3 cases, but he can choose one amongst those 3 that, okay, I want to file this case against this certain person only. So that's why we say the type of liability that we have is joint and several. For vicarious liability, what we will get 4 different relations. For all these 4 relations, liability is joint and several. Either make them jointly liable or you make them liable separately, depends on the victim. However, to make the other person liable, there should be existence of any of the following relationships between them. We cannot randomly make any person liable for somebody else's wrong. But to make someone liable for another person's wrong, there has to be existence of some kind of a relation between the two. And what kind of relation? We have 3 different types of relations. In presence of these, we can make them liable. Okay, so the relations are principal and agent, partners, master servant, employer and employee. What is principal and agent? Under Indian Contract Act, we get a certain type, right? Like we have this contract of agency.
Yes.
There one person is superior, one person is like the principal, another person is appointed as his agent, principal agent. Same ways we have Partnership Act that mentions what is a relation of partnership, right? Same ways master servant, we all are aware. There are different types of contracts which are not being defined. Same ways employer and employee, there may be some offer letter or some kind of a contract between them. So all these 4 relations, we may make someone liable for somebody else's wrong. But whom will we make liable for whose wrong? Right? For that, we have 2 concepts. Okay, so we have 2 concepts, like why are we even making someone else liable for somebody else's wrong? What is the reason behind that, right? For that, we have 2 maxims. or two concepts which explain us this entire thing. Why are we making someone else liable? Plus whom to make liable. Okay, in these relations, there are two persons, right? At least two persons are there. So whom we should be making liable? For that, we have two Latin maxims. First one being respondent superior, which means let the superior be liable or responsible. As in all these relations, if we look at these relations, there is one person who is superior, there is one person who is inferior. Okay, and in what terms they are superior and inferior? In terms of their authority. One person can give directions, other one cannot give directions, he will have to follow it. Okay, same ways in case of torts or in case of civil wrong, the main aim is to provide compensation, right? We want to provide compensation, we want to reduce the loss that the person has suffered. So we consider that out of these two persons, one is financially also better situated. He or she can better compensate the victim as compared to the inferior one. Okay, so these are the two reasons why we are making the superior liable. That superior one is the one who is having like the authority and he is in a better position to compensate. Main aim in civil law is to compensate, so rather make that person liable. Okay, so based on this concept, we can make somebody else liable for someone else's wrong as well. Okay, is it clear?
Clear, yes, madam.
Second one we have is qui fecit per alium fecit per se. So this maxim means he who acts through another does the act himself. He as in the superior one. Like I said, the superior one is better situated. The superior one is in a position to give orders, directions, etc. Okay, so he, that is the superior one, who acts through another. Actually, it's that the superior one wants to get something done, but he is not doing it himself. He is giving the directions to someone else that you get this certain thing done. So it's as if he is doing the act himself, because ultimately the idea was his, he was giving the directions, he was giving the orders. It's as if he has done it himself. Okay, so qui fecit per alium fecit per se, it means that if you are the one who is giving directions, who is giving orders, just that you are getting it done through another. It's same as if you have done it, because ultimately it was your idea, your plan and everything. So why should we be making the other one liable who had no other option but to follow your orders, right? So we should rather be making the one liable who directed this entire thing. So this is the second reason why we make the superior one or the other person liable, why we have the concept of joint and several liability. For example, there is master and servant relationship. One person is a master, another one is servant. Master do not like his neighbors. Okay, so what master is saying is, master is giving an order to his servant that you go to my neighbor's premises and throw all the garbage there. Servant is not having any other option. Servant is simply following the orders of the master. So in such a case, it was the master who was giving the orders, who was giving the directions. So there is no point that we make the servant liable, right? It was ultimately the master who was giving all the orders and everything. So rather, their liability be joint and several. Okay.
Yes.
So these two maxims we need to remember, which tells us what is the reason that we are like making somebody else liable. Yeah. One second, okay. All right, so these are the three relations which we have. Liability of the principal for the tort of his agent. First one is making the principal liable for the wrong or for the tort that the agent has committed. So principal is vicariously liable for the tort committed by an agent in performance of his duties as an agent. It is not essential that the tort must be authorized by the principal expressly. Authorization of the act may be express or implied. Express as in something which is like clearly expressed, clearly written, etc. Implied as in it is implied. Okay, it is implied from the actions or from the behavior. So it is enough, even though it was implied, that impliedly you have authorized that certain act. That is also enough. Like mostly we see LIC appoints or hires some agents, and then they tell about the different policies and say that, okay, fine, what you can do is you can go to prospective customers, you can tell them about the policies, and you can convince them to buy the policy. Once they buy the policy, you can even do home collection. You can collect the money from them. They don't need to like travel all the way to LIC office to deposit the money. Rather, you can collect the money, you can deposit it in LIC office.
Yes.
And in this process, there are a lot of cases wherein LIC agents try to misappropriate the money, as in they collect the money, but then they never deposit it in LIC office. After a few months, the policyholder comes to know about it, and by that time, their policy will lapse. Right? So in such cases, policyholder can file a case against the agent, against LIC, or jointly against both of them also. So that is a very common example which we see, and a lot of cases are also being filed for this matter. Okay, so this is an example of principal and agent relationship wherein agents are being authorized. So agents are as such not being told that, okay, fine, you can, like collect money and then you can misappropriate it. But LIC has given them the authority that you can collect the money. If after that they are misappropriating it, as in it is LIC's responsibility also. So we see a lot many cases being filed against LIC in such a matter. Okay.
Yes.
Now there was this case, okay, where like we see, right, there are a lot of real estate agencies. Have you seen like that roadside? There will be small offices. They will say we are a real estate agency, right? We help in selling and buying properties, getting a rented house, finding a rented house and stuff. Same ways, this was also like an agency. You can consider like a real estate agency. What they do is they give expert advice. Okay, like take for example, you have a plot of land and you do not have lot of knowledge on how you can maximize your profit by using that plot of land. In such cases, this is like an agency who will help you with expert advice. So what kind of expert advice they will give, that what can you do with your property and everything. Now what happened in this case is there was this plaintiff. Okay, plaintiff was there and plaintiff was having 2 cottages. Okay, plaintiff was having 2 cottages and plaintiff approached the defendant to get advice regarding how she can earn income from this property. So she was having 2 cottages and she did not have enough knowledge on how she can earn profit from this property. So she thought that what I will do is I will go to this agency and I will like take their advice, because they are like professional people. I will take their advice to maximize my profit. Now in that particular like company, okay, Smith and Company, there was a managing clerk. Okay, usually what happens, there might be like a company owner and he will hire some managers and all, and managers are usually given all the authority. You can take like complete decisions and everything. So this managing clerk was authorized, okay? Managing clerk of the defendant company was authorized that if a client comes, you can give advice and you can get it executed also. Whatever is required to get the advice executed, you can do that. Like you don't need a thought, like permission or approval from the owner, you can get it done yourself. Managing clerk was given that much of authority. So managing clerk of the defendant company asked the women to sign on two papers, and he made an impression as if it was a sale deed. So he gave an impression that how you can maximize your profit, you can sell both these two cottages and you will be able to earn enough money. So what you do is you sign on these two papers which were supposed to be sale deeds. She also signed on these papers, but in reality, these were not sale deeds. Okay, these papers were gift deeds. That she is gifting those two cottages for free to the managing clerk, not to the company, to the managing clerk. Okay, so in reality, the papers were gift deed in favor of the managing clerk himself. Later on, the plaintiff came to know about it. She came to know that, okay, it was not a sale deed, it was rather a gift deed. So plaintiff filed a case against the agency, against the company. She filed a case for playing fraud on her. Now, case was not filed against the managing clerk, it was filed against the company. It was contended that because the managing clerk acted for his personal benefit and without knowledge of the principal, therefore principal is not liable for the same. This company owner, he went to the court and he said that it was the gift deed was not in favor of the company, not in favor of me, but it was in favor of the managing clerk. So we should not be held liable in this case. And also, this was without my knowledge. I was not aware of this certain thing happening, right? But court rejected both these two arguments, and it was held that because the agent was acting under the authority given by the principal to do certain type of duty on his behalf, he was liable for the fraud committed by agent. Like we mentioned, it might be express or implied. You have given the authority.
Yes.
Right? So you have given the authority. If you should have, like taken bit of precaution, like mostly we see movies and all, right? Everything would be done by other people, but the owner of the company will sit and entire day he will only be signing different files, and while signing he would even like go through the papers as well. Why? Because they do not want to take that risk. They want to ensure that whatever things are being authorized, it is proper. So you could have taken that precaution. You have not taken it. You only authorize the managing clerk. You only gave entire authority that you can do whatever is needed to execute the advice, right? So in such a case, you cannot escape the liability because as an agent of that particular company only he was acting, and in that capacity only he got the authority to play fraud against her. Okay, so this is nothing but an agent who was performing his duties which were given to him, which were authorized to him. And in such a case, he is committing a fraud, so we can make the company also vicariously liable. Okay. So what is happening here? It is that the company had authorized the person, right? And that's why court said that no, you are vicariously liable. Same ways LIC, right? LIC also authorizes its agents that you can do home collection in order to make this entire process convenient for our customers. There also LIC can be held liable because LIC is authorizing the agents. But this is not applicable in this case, which is like completely different. What is this case all about? It is State Bank of India versus Shyama Devi. Now there are, like these days, especially there are some private banks where they are authorizing their agents that, like, if I want to deposit a certain amount of money in my bank account, I need not go to the account. like branch. Okay, I can even request for home collection. Employees would come and collect the money from me and give it. There are some private banks who are doing it these days, but then when we talk about SBI has not authorized its bankers to do that, right? They will sit in the bank. Whatever services you need to go visit the branch. There only you will get it. Okay, so what happened in this case is SBI versus Shyama Devi. In this case, plaintiff's husband. Okay, plaintiff as in Shyama Devi. Okay, this was, I think, an appeal which was being filed. So Shyama Devi's husband gave some amount and a check to his friend for depositing in plaintiff's account. As in, Shyama Devi was having a bank account in SBI. Okay, Shyama Devi was having a bank account in SBI, and Shyama Devi's neighbor was a banker in SBI. So what her husband did is, her husband wanted to deposit some amount of money in the bank and also honor a check. So what he thought rather is that I will give this amount plus the check to this friend who is anyways a banker of SBI, and we don't need to go to the branch. So he gave this amount to this friend who is a banker of SBI and asked him that you deposit it in my wife's bank account, SBI bank account. Okay. The friend was an employee of the defendant's bank. He was an employee of SBI. He took the money, he took the check, but what he did is, in place of depositing the money and check, he misappropriated it. He used it for himself. He never deposited it in plaintiff's bank account. It was held by the court that defendant was not liable for the same because wrongdoer was acting in his personal capacity and not as an employee of the bank. While he misappropriated the money, while he took it, he was acting as a friend, right? He was not acting as a banker and an account holder, but they were acting in a relation of friends, neighbors, etc. So in such a case, because SBI has not authorized that you can do home collection or something like that, checks need to be dropped in the check drop box. If you are doing some transaction in your personal like relations or something, there SBI will not be liable because it's not something which SBI has authorized. So in this case, court said that yes, while this banker was misappropriating the money and the check, he was acting as a friend of account holder and not as a banker. So in such a case, SBI is not liable. Court did not hold SBI liable because of absence of requisite relationship and authority while misappropriating the money. In this particular case, previous example, it was the company who had given authority to managing clerk. But in this case, SBI has not given authority to the banker. Right? So if he is doing something in his personal capacity, their bank will not be liable.
Responsible.
Okay, so express or implied, it has to be there. If it is not there, we cannot simply make the other one liable for every single thing that happens. Okay, liability of partners for each other tort. Now, in case of agency, principal and agency, fine, principal is superior, agent is inferior. Who is inferior and who is superior in case of partnership?
Both are equally superior and inferior.
Both are at the same time superior, at the same time inferior. That is why we say that they are partners of it, like they are like agents of each other. They are principals, they are agents also at the same time, correct? So liability of partners for each other's tort. The relationship between partners is that of principal and agent, where each partner acts as an agent of other, because we cannot say this one is superior, this one is inferior or something like that. Both are agents, both are principals. In case any partner commits any tortious act in the course of business of the firm, all other partners are liable for wrongful act. If someone is doing it, we can make all of them liable also. Victim can sue all or any of the partners for the compensation of loss suffered by him. Whatever loss is being suffered, for that he can file a case against all of them, any of them, some of them. If there are three partners, A, B, and C, we can make them jointly or severally liable. If C has done something wrong, you either file the case against A, B, or against C, or against jointly A, B, B, C, or C, A, or against all of them. That depends on the victim, because all are at the same level over here. Okay.
Yes.
Next one is liability of the master for the tort of his servant. So in case a servant commits a tort in the course of employment, then except the master, except the servant, master will also be held liable. Servant is a person who carries out work, okay, who carries out work under the control and direction of master. It's very important to know who is a servant, because servant is different from an independent contractor. Servant is someone to whom master is giving constant directions and orders. Okay, and whatever master is saying, servant is performing based on that. Servant is basically not applying his own mind, rather he is following the directions.
Yes.
But when we talk about an independent contractor, in case of an independent contractor, the master tells him what is to be done. He is not giving exact instructions as such. All right, like take for example, you can say maybe you want to renovate your house. Okay, there are so many agencies these days, right? Interior decorator and so many other things.
Yes.
Take for example, you are going to some interior decorator and you have said that, okay, this is my budget, what plan you have? And they say that, okay, we have this plan, we will get everything renovated. In such a case, what do? You just tell them that, okay, I want to renovate my house in this way, like this theme, like that. These are the colors I like and stuff you tell. Everything else they will do, right? Most of them will say that, okay, you vacate the house, you go somewhere on a vacation, we will get everything done. After a week, we will hand it over to you. That means they are independently doing everything. You have just told them what is to be done, right? What is to be done. They are independent contractors. But take for example, you are hiring a local like painter or somebody, okay, and you are giving them instructions full on that I want to paint my house inside and out. First of all, you need to paint it from inside. 2 coatings you give. First you paint the hall, then you paint the drawing room, this, then you paint the bedroom, this color, that color, this wall first, that wall second. As in you are giving directions. That is nothing but a servant. Okay, so this difference we need to make. In case of master and servant only, vicarious liability comes. For independent contractors, it will not come, except for some exceptions like absolute liability, or if the master is only authorizing that, okay, you do this illegal act. For an illegal act, if they are authorizing, their liability would come. But in general, for independent contractor, liability will not come. Okay. So liability for consequences of handing over extra hazardous work. So these are the situations where for independent contractor it can come, but otherwise it is master and servant only. When a person is giving directions and everything, there he will be held liable for whatever wrong is being committed by the servant. Okay, and last one being employer and employee. So employer and employee, again, employer is superior, employee is inferior. Most of the times it happens that employer will assign the work, give directions and everything, and employee would simply perform it. In such a position, if something wrong happens, there also we can make the employer liable. Like mostly we see, right, if you are ordering something online, okay, might be that while delivering the item, the package was broken or something happened in rain, it got damaged or something. It was a mistake from the part of employee, that employee did not carry it properly. But we do not make the employee liable, right? We directly call that certain online platform and then we would tell them that this is what has happened. As in, we are making the entity liable. Same ways, if we take the example of Amazon, right? It's not like Amazon is selling something, they are having different vendors. Even after that, if something is wrong with the product, we call Amazon and Amazon tries to resolve the issue. Why? Because they are kind of like employees of Amazon and there they take up the responsibility, right? So when we talk about employer and employee, again, employer being in a superior position can be held liable for the torts committed by employee, but again, it has to be within the course of employment. It has to be something which is being authorized. Like that example of agency, which we have seen, right? It was authorized, but SBI thing was not authorized. It was not within course of employment. He was acting as a friend of his neighbor, right? So if it is something which is within the course of employment, we can make the employer liable in such a case. Okay, is it clear?
Yes, madam, clear.